On receipt of appointment orders, the inquiry officer has to ensure whether the above orders were issued by the competent authority and copies of the above orders were communicated to the accused with directions, and a copy of charge memo with connected evidence records were attached. Immediately, the inquiry officer has to issue summons to the accused, prosecution and defense witnesses, fixing up a date, allowing a reasonable time for a preliminary hearing. The inquiry officer has to keep record of evidences for having delivered the above summons to all concerned. On the day of preliminary inquiry, in the presence of all concerned, the inquiry officer has to read aloud all the charges framed against the accused. In the presence of the accused, all witnesses have to be inquired. The evidences have to be inquired following Evidence Act. Prosecution evidences have to be inquired, and the accused has to be asked to cross-examine them following the deposition of prosecution evidences. Evidences must be voluntarily, and there must not be spoon feeding. The cross-examination by the accused must be within the depositions by the evidences. The witnesses must be assigned as prosecution witnesses number 1, 2, 3, etc. Any documents if produced as prosecution evidence, it must be shown to the accused and then assigned as prosecution evidence number 1, 2, 3, etc. The accused must be asked to cross-examine them. A witness belongs to neither prosecution side nor defense. He is called as court witness. Court witness can be cross-examined by both the prosecution and defense. Prosecution witnesses cannot be cross-examined by prosecution side except in case of who does not voluntarily disclose evidences. Similarly, defense witnesses cannot be cross-examined by defense side except in case of defense witnesses who does not voluntarily disclose evidences. The inquiry officer has to ensure before such examinations that cross-examination of such evidences would result in the disclosure of facts connected to the case and then may permit for such cross-examinations. Recross examinations follow the cross-examination. All such proceedings have to be recorded in writing, and the signatures of all those who were present during the proceedings have to be obtained. Copy of proceedings has to be handed over to the accused and acknowledgement obtained. If necessary, the inquiry officer may announce fixing up another date for the main enquiry and signatures obtained from all.